This is Bloomberg Law with June Grasso from Bloomberg Radio.
A reprieve for nearly 12,000 Afghans. An appeals court stepped in to keep protections in place that have prevented the Trump administration from deporting them. That's at least until Monday, while both sides file legal briefs and the Fourth Circuit Court of Appeals makes a decision. The Trump administration has moved aggressively to remove temporary protected status from Afghans and hundreds of thousands of people from 6 other countries as part of the administration's effort to ramp up deportations. Joining me is Samuel Siegel, Senior Counsel at the Institute for Constitutional Advocacy and Protection at Georgetown Law. Along with the Washington Lawyers Committee, it's representing CASA, a nonprofit immigrant advocacy group that sued the administration over the TPS revocation for Afghans as well as for people from Cameroon. So before the appeals court stepped in, the Trump administration had planned to end temporary protected status for Afghans. Tell us about that.
So the Trump administration had announced that it was ending temporary protected status for Afghanistan this week. It announced that the conditions that initially led to the designation of that country, the ongoing armed conflict between Taliban and other insurgent groups, and the extraordinary humanitarian conditions were essentially no longer so severe that it merited that designation. I guess to take a step back and talk a little bit about TPS. TPS is a status that the Secretary of Homeland Security can designate a particular country for based on certain conditions in those countries, particularly if the country is experiencing an ongoing armed conflict, if there's a natural disaster, or if there's another extraordinary condition in the country. If the Secretary makes that conclusion, then he or she will designate the country for TPS, which allows individuals from those countries to live and work in this country for a particular set period of time. Secretary Mayorkas concluded that Afghanistan merited that determination back in 2022 and extended in 2023 based on those conflicts and the conditions in Afghanistan. And Secretary Norm at least purported to say that those conditions no longer existed. Now, of course, our challenge, one of our arguments, is in fact that purported rationale for the decision is not the one that's actually motivating the actions here. Our argument is that this is a preordained decision as part of the Trump administration's broader effort to reduce the number of non-white immigrants in this country, and that's the basis on which we have asked the Fourth Circuit to pause the TPS determination while the appeal plays out. Are
you also arguing in this that what the Homeland Security Secretary determined, that, there are improvements in security and economic situations and that Afghan nationals can return, are you arguing that that's factually incorrect?
We're not making that specific argument, in part because of some jurisdictional bars on what the courts are allowed to consider. I think what we are is pointing to that the conditions in the country are not good, and this further supports the argument that the purported rationales that things have improved are not the actual ones. So it's that mismatch between what's actually going on in Afghanistan and the actions here that support our argument that even if things might have improved a little bit, that's not really the reason that she's doing that. And I will just note to this effect, as part of the litigation here, the administration had to produce an administrative record, which is all the things that were in front of the secretary when she made her decision. And in November of 2024, the U.S. Customs and Immigration Service, which is one of the entities that typically consults on these, concluded that, and I'm going to quote here, quote, Afghanistan's civilian population faces dire challenges, including a collapsing economy and healthcare system, ubiquitous food insecurity exacerbated by drought, and widespread insecurity due to decades of armed conflict and insurgency that is entering a new danger phase. It also stated that the Taliban authorities violently target citizens and foster continued armed conflict and interethnic strife, and that it imposed severe restrictions on education, employment, and other areas on women that foreclosed their ability to meaningfully participate in their country. So again, we're not necessarily challenging the underlying factual conclusion of what's going on here, but we're saying that these kinds of statements from the federal government itself demonstrate that there's really something else going on here.
So Maryland federal judge Theodore So federal Judge Chuang allowed your challenge to TPS to go forward, but he declined to halt the administration's policy and, preserve TPS protections. He found that your group hadn't established sufficient likelihood of success on the merits. Will you explain why he thought that you wouldn't succeed on the merits here?
I think Judge Chuang issued a well-considered and balanced opinion. He concluded, as you said, that our challenge can go ahead, notwithstanding a couple of jurisdictional arguments that the defendants had raised. And he also concluded by pointing to things like the U.S. Custom and Immigration Service report that I just quoted, that we had plausibly alleged that the action taken with respect to Afghanistan is part of a broader policy to reduce the number of non-white immigrants in this country and to effectively terminate almost all TPS designations. But then he said we had not yet introduced enough evidence to sort of get over that likelihood of the success on the merits hump. And so there's some delta there in his mind that we hadn't yet demonstrated that we could get there. And he said, look, I'm going to allow this claim to go forward. You all can go into discovery and try and identify additional evidence that will support your claim here. But at this point, I'm not going to enter relief. So we respectfully disagree with that part of Judge Chuang's ruling. We think that the allegations that we made here and the evidence before the court was sufficient to, at a minimum, temporarily pause the termination of Afghanistan's TPS designation while we get that discovery, while things play out. And that's sort of the similar request that we've made of the Fourth Circuit, is just to postpone this agency action while the appeal plays out. And one thing I'll just note here, Judge Chuang noted that other courts have entered preliminary relief of some sort in response to similar claims and similar amounts of evidence in the past, in the first Trump administration, and said, well, we hadn't produced enough evidence here. I think it's important to note that in those cases, the time between when the end of the TPS designation was announced and when it took effect was, in most cases, more than a year. So those parties had, much more time to produce the kind of evidence that Judge Chuang is asking for. When we're asking for just this sort of temporary relief while things are playing out to the merits, we think that, first of all, the evidence that we have produced and the things that we've pointed to, like the thing from USCS that I pointed you to, like some other statements from President Trump and Secretary Noem, demonstrate that this is part of a preordained effort and demonstrate that we will likely succeed on the merits when we get there, especially as we get into discovery and produce more evidence in support of our argument.
So the Fourth Circuit gave you an administrative stay for a week. What's happening in that week?
Right. So for right now, as you mentioned at the outset, the Afghan TPS designation was set to expire on Monday. By virtue of the Fourth Circuit's decision, it postpones that action for at least that week, which means that Afghans who are facing the possibility of either having to leave this country or exist in some legal limbo and not be able to work are able to do so for at least this week. In the interim, the court has asked us to brief our request, formally called a postponement of agency action pending appeal. The federal government's brief is due by 11:59 p.m. Eastern tonight, and then we have 24 hours to return around a reply, and then we'll get a decision presumably at some point before next week, Monday, at 11:59 p.m.
Is this a losing battle in the end because if and when it reaches the Supreme Court, you're not likely to find a receptive audience, at least among the conservative justices? At the end of May, the Supreme Court allowed the Trump administration to immediately strip the legal right to temporarily live and work in the U.S. from as many as 500,000 people from Cuba, Haiti, Nicaragua, and Venezuela. And that followed another order in May that allowed the administration to end TPS protections for 350,000 Venezuelans. So is the Supreme Court likely to end TPS protections for Afghans as well?
Right. So I don't want to make too many predictions about exactly what the Supreme Court is going to do here. I will say that we're very confident in our case, and I'd just like to parse out those prior grants of, stays of lower courts orders. So With respect to the Cubans, Haitians, Venezuelans, and Nicaraguans, that was actually with respect to a parole program that had been adopted by the Biden administration. So it didn't involve temporary protected status. And I think, sort of trying to extrapolate what the court said there and apply it here, I think is a very difficult thing. Similarly, with respect to the Venezuelan program, that was respect to the temporary protected status. But in that case, the arguments that were being made were different from the ones that are being made here. There, for example, the plaintiffs argued that Secretary Mayorkas, who had extended the TPS designation for Venezuela for about 18 months at the end of the Biden administration, and then Secretary Noem had revoked that extension. The plaintiffs there argued that Secretary Noem doesn't have that sort of authority. We, by contrast here, are arguing that the reasons that were given were pretextual, that this was a preordained effort. Also, I think there are extremely strong equities here, as Judge Chuang recognized in his decision. I mean, with Afghans in particular, we're talking about individuals who served our country. One of the members of CASA, who's our client here, is a person named B.S., who faced death threats due to her work as an interpreter for international and United States agencies. And she's fearful that if she's returned, she's going to be targeted by the Taliban if she goes back to Afghanistan. So, again, I think it's always a little bit of a hazardous proposition of guessing what the Supreme Court might do if we get there. But we think that we've got a very strong case, and that what the court did with respect to Venezuela and with respect to the parole program doesn't shed all that much light on what it might do here.
So can some of the Afghans that you're representing apply for special immigrant visas or asylum?
Some may be able to, but I think it's important to emphasize here that TPS is, the bird in the hand. It guarantees them the ability to be in this country. It guarantees them the ability to work in this country. It guarantees them, under the statute, they cannot be put in detention on the basis of their immigration status. Things that may not apply to everyone that is securing, or in the process at least of securing, relief through other means. So there might be other things that are available. Whether or not they will ever be able to take advantage of those status, who knows, especially as this administration has assiduously worked to make those kinds of relief further out of reach.
One of the things the White House press secretary said was that temporary protected status was never intended to be a de facto asylum program, and that it's, not supposed to be renewed over and over again.
And I think that's certainly right. I mean, it's baked into the name temporary protected status. But there are specific criteria that the secretary is supposed to analyze in good faith in determining whether or not to designate a country in the first place and to extend, including, for example, whether or not there's an ongoing armed conflict there. And when the secretary offers reasons that are contrary to one or offers reasons that are pretextual, we just don't think that that's a basis for being able to terminate a TPS protection. If she makes a good faith assessment, then this can be terminated, and TPS designations have been terminated in the past. She just hasn't done what the statute requires in this instance.
Thanks so much for joining me. That's Samuel Siegel, Senior Counsel at the Institute for Constitutional Advocacy and Protection at Georgetown Law.
I will now go to voting because we have competing markups and other committees, and people have to leave here soon. We'll go to Bove's nomination. The clerk will call the roll.
Mr. Chairman, point of personal privilege.
Mr. Chairman.
Mr. Chairman, according to Rule 4 of the committee, we have the right to continue to debate this nomination.
No.
I'm invoking Rule 4 of the committee. We have the right to debate this nomination.
You're out of order.
I'm seconding
Mr.
Senator
Chairman.
Booker's demand for a vote on his request to hear from the whistleblower.
Mr. Chairman, you should at least acknowledge my Rule 4 point of order.
You're out of order.
I don't understand this. What are you afraid of about even debating this?
by proxy,
putting things on the record, hearing from every senator? Dear God, that's what our obligations are.
It was an unusual scene in the Senate Judiciary Committee today as Republican Chair Chuck Grassley called the roll over the protests of Democratic Senator Cory Booker that Grassley was violating the rules of the committee by cutting off debate on the controversial nomination of Emil Bove, President Trump's former criminal lawyer, to a lifetime appointment on the Third Circuit Court of Appeals. The Democratic senators stormed out of the room as the Republicans unanimously voted to advance Bove's nomination to the full Senate. Since January, Bove has been serving as the principal deputy attorney general, overseeing dozens of firings of prosecutors who worked on January 6th connected cases and the dismissal of bribery charges against New York City Mayor Eric Adams, which prompted the resignation of 7 veteran prosecutors in New York. Democrats had wanted to hear from a whistleblower, a former Justice Department lawyer who alleged that Bove encouraged lawyers to defy court orders using foul language, something Bove denied when asked by Democratic Senator Adam Schiff during his confirmation hearings.
Senator, I have no recollection of saying anything of that kind. To the extent I
Wouldn't you recall, Mr. Bove, if you said or suggested during a meeting with Justice Department lawyers that maybe they should consider telling the court, you? It seems to me that would be something you'd remember, unless that's the kind of thing you say frequently.
Joining me is Dave Aronberg, former Palm Beach County state attorney. Dave, the Democrats just wanted to hear from this whistleblower who's backed up his allegations with text messages. Why did the Republicans even refuse to call him, leading to this showdown, which is probably getting more attention than his testimony would have?
Elections have consequences is what's going on. Donald Trump ran to be everyone's retribution, the people who want to get back at other people in government, to go after the deep state, to fire people at the DOJ, and Emil Bove has been his henchman. And now he's going to get a lifetime appointment to a prominent appellate court. And there's been some buzz that Trump ultimately wants him to be on the Supreme Court. But first things first, shouldn't be surprised that the process is not up to snuff, because when it comes to doing favors for the boss, the Republicans will roll over. If you're going to bet on Republicans to stand up to President Trump or to follow the traditional rules and norms like they do, like it's been done for hundreds of years in the Senate, you'll be waiting a long time and you'll be disappointed.
There's been a lot of opposition from different camps to Bove. Yesterday, more than 900 former Justice Department lawyers signed a letter to the Judiciary Committee urging the Senate to reject his nomination. Do you think this means that Republicans will advance every judicial nomination that Trump makes?
Well, Bove is different than the others because Bove was Trump's personal lawyer, and he's Trump's personal pick. This is not someone that was recommended to him by the Federalist Society or some outside group. This is someone Trump wanted because Trump believes he will give Trump loyalty. And he resents, meaning Trump resents the Federalist Society and the old school conservatives who promised him that these judges would be constitutionalists and good judges. Trump interpreted that to mean loyal to him. And so that's why Trump says, all right, he doesn't like Leonard Leo anymore, the Federalist Society. He's just going to nominate people who'll be loyal to him and do his bidding and help him weaponize not just the DOJ, but also the bench.
And this is the reason why judges, even Republican judges, are not retiring recently because, it was one thing when Trump was appointing judges in the classic mold of conservative judges. Right. But now he's appointing loyalists.
Well, because Trump's not a traditional Republican. Trump only became a Republican later in life. He's a Trumpian. He's MAGA. It's different. And you're seeing the split within the Republican Party now, based on Jeffrey Epstein, when it comes to MAGA turning on Donald Trump. But MAGA is not loyal to the Republican Party. If Trump tells MAGA to start its own party, they will. And so he doesn't care about judges who are there as strict constructionalists or are going to be good for traditional Republican and business interests. No, he wants people who are loyal to him. And that's why he wants Emil Bove in the court. And that's why he's slow in nominating judges this time around. Remember, in the first term, he was like a house on fire. He nominated a ton of judges early on with the help of Mitch McConnell. But now he doesn't want those judges. He wants people who are loyal to him. And that's why it's harder to find folks who are qualified who meet that standard.
Let's turn to Attorney General Pam Bondi, who's been in the news a lot lately. And a case that I find startling, stunning. There's a plastic surgeon who is accused of conspiracy to defraud the government, among other things, selling about 1,900 fake COVID vaccination cards for nearly $97,000 $28,000, destroying more than $28,000 of government-provided COVID vaccines. So he's on trial in Utah. The prosecution is presenting its witnesses. 5 days into the prosecution's case, Bondi decides to drop the case. So she orders the prosecutors to drop the case and dismiss the charges. Have you ever heard of an instance where an attorney general in mid-trial dismissed charges?
I can't think of one instance other than this. This was a cause celeb on the far right, the MAGA world. Marjorie Taylor Greene was lobbying for him, and someone got the attorney general's ear and made her believe this was a political prosecution, that this guy is targeted because he was helping parents have a choice of whether or not to vaccinate their kids. Instead, he was injecting them with saline. He was deceiving authorities and helping parents in that way who wanted to buck the rules at the time. So on the far right, this guy is seen as a hero. And since he is being prosecuted, not others like this, I don't think there's any other case we know of like this, that was used to say, see, he's being singled out, even though others did the same thing. That's questionable, but being singled out. And with all the pressure from the Marjorie Taylor Greenes of the world, especially when you have everything going on, when Marjorie Taylor Greene and others in the MAGA world are turning on the Trump administration because of Epstein, well, this was perhaps the right time to do them a solid.
What's also stunning is that Bondi credited Congresswoman Marjorie Taylor Greene and Senator Mike Lee on social media. So the Attorney General giving credit to political leaders for dropping a case. Does this show that the Justice Department is not maintaining a division between politics and its prosecutorial decisions?
Remember what I said at the beginning of this interview? Elections have consequences. The voters chose a person who said that I will be your retribution, and they made it clear that he was going to turn the DOJ into an agency that did his will, his bidding. And so we shouldn't be surprised now that if he wants to help a political supporter, especially one that's starting to turn on him because of Epstein, that he's going to do it. And ultimately, he makes the decisions. And it shouldn't be a surprise. This is what they campaigned on. Whenever someone says we're going to stop the weaponization of the Department of Justice, generally that means we're going to weaponize the Department of Justice.
By the way, that case, the Utah surgeon case, had gone through the weaponization group and passed the weaponization group.
Right. They had this whole group that's designed to root out cases motivated by politics. And that group, that committee, said, no, this is okay. This is legit. And then the decision was made to undo this case anyways. So this was the type of thing that Trump ran on, and it wasn't something that was totally out of the ordinary. I mean, we have seen presidents be very close to their attorneys general in the past. JFK appointed his brother to be attorney general. Barack Obama had his so-called wingman, Eric Holder, as his attorney general. It happens. But what we haven't seen are decisions that are at least obviously made because of politics. Now, does it happen anyways? Yes. But this is just like saying the quiet part out loud.
By the way, the defense attorney said that she thought that the prosecutors were joking when they called her on Saturday to say, we're dropping the charges in the middle of trial. So that shows how unusual it is. You mentioned the Epstein files, and Bondi is coming under fire. She's facing increasing anger from the GOP base and calls for her resignation over her handling of the Epstein files. Why do you think she went out up front and said, I have the list, it's on my desk?
Well, to be fair, June, she didn't say I have the list. It was asked of her on Fox News, said that there's a list, right? And then she said, I have it on my desk. So the implication is it's the list, but she then corrected herself afterwards to say that I meant I had his file on my desk. And actually, I believe that's what she meant. But at the time, when you're on TV and you get caught up in the moment with Fox News, you want to please people. And people on the far right were clamoring for the list. And you say something that was inexact, and it's come back to bite her. But in the end, there is no list. I mean, I was a state attorney in Palm Beach County 6 years after the Epstein stuff was over. And it's clear based on everyone I've spoken to and everything I've read outside the office. I had no access to any inside information. The grand jury reports that were all kept by the clerk, not by our office. But talking to prosecutors and reading about journalists, there is no list. And Epstein did kill himself. Now, that's different than the question of, are there third parties involved who should be prosecuted? Well, that's a different question. And the DOJ is saying, no, we're going to end it here. And I have thoughts about that. But in the end, I think Bondi was telling the truth that there is no list, and he did kill himself.
Coming up next, most Americans think the government is lying about the Epstein files. This is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's hard to put the genie back in the bottle. While campaigning last year, President Donald Trump promised to release files relating to Jeffrey Epstein. But this month, the Justice Department said that Epstein did not maintain a client list and said there was no additional information on the case to release. That sparked a furious reaction from many of Trump's supporters and repeated calls to release the files. Trump has attempted to tamp down the uproar with explanations like this.
It's all been a big hoax. It's perpetrated by the Democrats, and some stupid Republicans and foolish Republicans fall into the net, and so they try and do the Democrats' work.
But pressure continues to build on the Trump administration to release the Epstein files. And according to a new Reuters Ipsos poll, about 69% of Americans think the federal government is hiding details about Epstein's clients. That compares to just 6% who believe the government. I've been talking to Dave Aronberg, former Palm Beach County state attorney. Dave, not releasing the files seems to be feeding into the conspiracy theories that there's something there to hide. And it doesn't look like it's going to die down, so why not just release the files?
That's where they erred. They really did try to placate the conspiracy theorists in their base, of which there are many. In fact, Dan Bongino and Kash Patel came to power based on conspiracy theories. In fact, Donald Trump came to power based on conspiracy theories. He ran on Barack Obama being from Kenya. He then said the 2020 election was stolen. Both of them were false. They're both conspiracy theories. And then the third one on Jeffrey Epstein. And that one is coming back to bite him because the alligator is always hungry. And you can try to feed it, but eventually it's going to bite your face off. And that's what they've learned. They overpromised, and now the MAGA base is turning on them. And the facts are what they are. As far as why aren't they releasing the whole file? Well, a few reasons. It is standard practice. It is the norm that you don't release the names of individuals unless you're going to charge them within the DOJ. Of course, at the same time, this is the same DOJ and Trump administration that has been breaking norms. So this is the one norm they're adhering to. But I do think the real reason is that President Trump's name is caught up in this, not as doing anything illegal or involved with human trafficking or illicit sex rings, but just by being friends with this person, of which a lot of people were on Palm Beach. I don't think he wants, and his people don't want, his name to be out there and wants his story to end. But by blocking the release of all the documents, it keeps it going.
We've been talking about politically motivated dismissals of cases. Let's turn to politically motivated prosecutions of cases. Trump on Truth Social has accused Senator Adam Schiff of mortgage fraud and demanded that he be brought to justice. Schiff has flatly denied that he falsely designated his Maryland home as his primary residence. The request for the information on Schiff apparently came from the FHFA's Inspector General. It's also similar to the allegations that have been made against New York State Attorney General Letitia James. Does this chain of events seem unusual or troubling?
Well, it's easy to send something to the FBI and just say, look at this wrongdoing, especially if it involves an elected official. So we've seen this before about investigations that are politically motivated. The Russia probe of the investigators, the probe that John Durham and Bill Barr conducted to investigate the investigators that eventually blew up in their face because there are built-in safeguards, built-in guardrails for out-of-control prosecutors. If you go ahead and you start charging people without evidence, that case, first off, should get thrown out by the grand jury, will not be indicted by the grand jury. And if it does, if it meets that standard of evidence, which is relatively low, then a judge could throw it out. And then if it does ever get to a jury, the jury can do what it did in the John Durham cases and quickly acquit. And then the prosecutor has egg all over his or her face. So that's a cautionary tale. I've always said that Pam Bondi is a 20-year prosecutor. She will not cross the red line and trump up, to use a term, fake evidence to bring bogus charges against Trump's political enemies like Matt Gaetz would have. That's why Matt Gaetz was the first attorney general appointed by Donald Trump before he had to back out, because Gaetz promised to blow the place up. Bondi knows better, and she's not going to do that and cross the red line. And if that happens, have me on and I'll eat some crow.
I will remember that, Dave. There seems to be a continuing purge by Bondi of Justice Department lawyers. Federal prosecutor Maureen Comey, who worked on the criminal case of Jeffrey Epstein and Ghislaine Maxwell, was the prosecutor in the Sean Diddy Combs case, was fired yesterday. Comey is also the daughter of former FBI Director James Comey. It seems too coincidental.
Oh, it's not. If you have the last name of Comey and you work for this administration, you should prepare the boxes to remove the stuff from your desk. Same thing if you have the last name of Fauci or anyone else on Trump's target list. He hates Comey. He wants Comey prosecuted. So why is he going to allow his daughter to continue in her prominent role at the SDNY, especially after they lost a prominent case in Diddy? Now, I know they got the lesser charges, but they lost. They lost that case. So this was the time for them to do it. Do I agree with it? Do I like it? No. I think prosecutors should be judged based on their work product, not based on their last name. But again, this is the kind of stuff Trump campaigned on, being your retribution. I
mean, would a prosecutor be fired after losing one of the most high-profile trials since probably the most high-profile trial since Trump was elected?
No. Did Chris Darden and Marcia Clark get fired because they lost the O.J. Simpson case? No, that doesn't happen unless you're just incompetent at your job, and none of those people were incompetent. So the only one fired is the one who has the last name Comey.
In another Justice Department move that's already drawing fire from some California lawmakers, including Nancy Pelosi, Attorney General Pam Bondi this morning went on a tour of Alcatraz because President Trump is thinking of turning it back into a prison. Now, Alcatraz is currently a profit maker for the federal government. As a tourist attraction, it earns about $60 million a year. I didn't think they were really serious about this, but maybe they are. Why?
It's about the show. Trump loves performative art, and this is right up his alley. Remember the movie Escape from Alcatraz? And it's a symbol of being...
Great movie.
A great movie, right? Clint Eastwood. So Alcatraz is a symbol. It's the Rock. It's just a symbol of a government that was probably a little too obsessed with visuals, being tough on crime, when in reality it wasn't all that, and it's now a tourist site. Well, this is right up Trump's alley. All these other images of him being tough on crime, telling police to hit the suspect on the way in the car, let him bump the head on the car door on the way in. If that isn't enough, well, why not have the symbol of Alcatraz, no matter what the cost? After all, our government can just print money, right? And it's not like we're in massive deficits, are we?
The cost of refurbishing the island and building a new prison has been put at $250 million, at a minimum. Let's turn to the other Alcatraz, Alligator Alcatraz. Controversial, to say the least, immigration detention facility in your neck of the woods in Florida. The detainees are suing the Trump administration, alleging inhumane conditions and unlawful confinement.
Yeah, it's going to take time to wind through the courts. Maybe they'll get an injunction, and then the Supreme Court has curtailed injunctions, but they could get one for this facility. And from what I hear, they're right. It's not something that should be there, but this is, again, about show, not the go. This is about imagery. They're selling swag for Alligator Alcatraz. They're selling swag. Oh, yeah, it's on the Republican Party's website. Governor DeSantis is pushing it. This is performative art, and it plays into exactly Trump's strength, which is immigration and criminal migrants, even though the people there largely are not criminals. They're people who may have overstayed their visas, but they didn't commit crimes in the United States, at least not most of them we're hearing. The conditions are reportedly inhumane. The conditions may not even survive a low-level tropical storm, of which, unfortunately, Florida gets this time of year. It's already flooding even before there's ever been a tropical storm in the area. So is this something that we should be doing? No. Again, though, it is about a symbol. It's the same reason why they're trying to pay $250 million to restore the original Alcatraz. But at some point, you got to believe that voters may just say, what about substance? Is this kind of country we are where it's all about symbolism? It's about showing people how overly tough and harsh and punitive we are. Like maybe at some point we can just go back to our roots and just try to be that shining city on the hill.
A state representative, Angie Nixon, a Democratic state representative in Florida, is filing a separate suit against DeSantis challenging the legality of the site's construction on protected land. Is that protected land where it is?
Native Americans say it is. But, I mean, again, these lawsuits will take some time. And is she filing in state court or federal court? State court. If it's in state court, the appellate judges were all appointed by Republicans, and many of them were appointed by DeSantis and the Supreme Court of Florida, 6 out of 7 conservative majority. And so if it's a state court lawsuit, that ain't going anywhere. If it's a federal lawsuit, perhaps they could get an injunction. But this is going to wind its way through the courts. And the win here is not in keeping people there. That's not really the concern of DeSantis and Trump. They just want the imagery, and they like the imagery of having Democrats fight this because the Democrats are fighting this on the Republicans' terrain. It's much better for them to go to war on this than to go to war on Epstein or on tariffs, all notoriously unpopular.
It's hard to get away from the Epstein files, though. Thanks so much, Dave. That's Dave Aronberg, former Palm Beach County State Attorney. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.